Hi, welcome back to Inspired by Taja. My name is Tajalee, and today we will be talking about how employers file their H-2B petitions to get to hire foreign workers. So, most businesses file their request for workers with the U.S. government 120 days prior to the job start date. So employers may begin the recruitment process and start looking at resumes 4 to 5 months before the season begins. So one may ask, how does the employer establish a temporary need for H-2B workers? So the onus is on the employer to establish that requirement for H-2B visa holders is temporary to cover seasonal, peak load, intermittent, or one-off periods of employment. The employer usually provides contracts, written explanations, outlines of projects and their timeframes, or any other pertinent document that would be needed. So, U.S. employers are legally required to establish that the job is temporary only and does not exceed a period of 12 months or a year. They should also obtain the proper certification, and the employer or its authorized agents must file the application. So employers must allow a minimum of 60 days but no more than 120 days before workers are needed. So the process is a lengthy one, so employers need to allow sufficient time for any corrections or delays that may be a part of the petition filing process. So employers need to obtain a temporary labor certificate. So to do so, they need to submit Form ETA-9142 to the Department of Labor for permission to employ seasonal or temporary laborers. The labor certificate is legally valid for the specific time frame, the employer, employment, and number of foreign workers shown on this same certificate, as well as it is non-transferable and is limited to a specific employer or employment opportunity. So employers will need to file this certificate 60 days minimum and 120 days maximum prior to the first day that H-2B workers will begin their labor. So say for example, an employer requires an H-2B workers to start April 1st, then they have to submit this 160 days minimum to 120 days maximum prior to April 1st. So what will happen after is that the employer will then receive notification that the application is accepted for consideration. So after receiving the labor certificate, the employer or petitioner, they must file Form I-129. So the I-129 is a form submitted by employers to obtain a worker on a non-immigrant visa status. So it is used to either file for a new status or a change of status. So the I-129 in relation with your visa process is that it must be included in your visa application. So once the employer gets this form approved, what will happen once your visa process starts, then if you're going through an agency, for example, what will happen is that once you send them all the required documents that they would need, this is also needed, and it must be included when doing your visa application. So when the embassy sends your passport to the embassy with all the other documents, then it would include this form, this approved form as well, because it is needed for your visa approval. So after USCIS approves the form I-129, prospective H-2B workers outside the United States, they must apply for an H-2B visa with the Department of State at the consulate in their home country. So after your employer completes their part on their end as it relates to the H-2B process, then all that is required is that they will send you the required documents, or they send it to the agency, as I've said before, and then you will apply for your visa. So that's basically a summary of the process as it relates to when the employer files their petition. So next we'll move on to a few H-2B questions that persons normally ask. So persons normally ask, what are the requirements to be eligible for the H-2B program? So first, you need to be at least 18 years of age, be willing to work in unskilled positions, have a valid job offer from a U.S. employer to perform seasonal work, and also bear in mind this employer must file a petition to be eligible to hire foreign workers. So it's not just going out there and applying to any employer in the United States, but this particular employer with whom you reach out to, they should file a petition. So they should be looking to seek H-2B workers. And also you must have an intermediate level of English. So also a person mentioned, asked a question in the comment section of a previous video. So this particular person asked if there's an age limit for the H-2B program. So really and truly there is no age limit. However, employers do prefer to take candidates between the years of 18 to 50 years old. Another question persons ask is, what are the fees for the H-2B program? So it's important to note that there's no fees involved. H-2B employers are responsible for paying agency recruitment fees and the workers' transportation and visa voucher fees. So H-2B workers are responsible. So what we are responsible for are our housing costs and related expenses upon getting into the United States. So persons also often ask how long an H-2B visa holder can remain in the United States. So visa holders are permitted to stay in the United States only for the period of employment which your visa will state. So if approved for an H-2B visa, then it will have the issue date, or it will have the petition start date and also the end date. So for example, if an employer is petitioning for you for April 1st start date, then the visa will have that, as well as it will have the end date, which would be, for example, October 30th. So just a quick correction, it will have the issue date, that's the day the visa was issued, and it will also have the end date, which is the ending of the petition. So the initial period can be 12 months or less. However, extensions can be obtained for a total of 3 years. And in a separate video, we will definitely talk about H-2B extensions and how you go about applying for that as well. So another question asked is, can dependents join me in the US on the H-2B visa? So based on the USCIS website, yes, they can. So this is dependent spouses and unmarried children under the years of 21. They are granted H-4 visas and are eligible to join H-2B visa workers for the duration of their visa. So as we stated previously, if your visa starts April 1st and ends October 15th, for example, then if you should go ahead and take on your dependent or your spouse with you, then their visa, the H4 visa, would have the same time frame as it relates to the issue date and the expiration date as well. So it would be the same as yours. So the process of applying for an H4 visa, so it all depends based on research that I have done, I'm speaking on. So far what I've researched and come to realize is that your employer has to be in agreement with you bringing your spouse or your child or children with you to the United States. So initially, as we mentioned before, persons do an extension. So say for example, the H-2B worker is in the States, or not only extension, but say for example, you go up April, and say for example you reach like July in your contract, and you are thinking about getting your child to come up with you. Based on what I've researched, that would not be possible for you to bring your child with you. You would have to be in Jamaica at the time. So they would leave with you the same period, in the same period which you apply for your H-2B visa, then it's the same period in which you would apply for their H-4 visa. So as I've stated, you would have to be in Jamaica applying, and the employer hiring you would add the child or children or your spouse to the petition. That's based on what I understand from it. So both embassy and the employer would need to know who would take care of them while they're there. Say for example, you're bringing a child. I'm going to use a child in this instance. So they would want to know who would take care of him or her while they're there and you are at work. They would want to know what's the reason for them coming to the US with you, and also they would need to know the age of the child that you are planning to bring with you. On the website as well, I've seen where if you should take your child over, so as for your spouse, they are not allowed to work on the H-4 visa, but your child, they can go to school on the H-4 visa. So it is definitely doable. It's just that we haven't heard many cases of where persons actually got through with this visa, or we haven't heard of persons thinking about getting this visa, because normally when we think of going overseas to work, then if we have children, we would automatically leave them in the care of someone else, of someone we trust, or we would find someone to supervise and take care of them. So we haven't heard of many cases of the H-2B visa, but I definitely know that it is something that persons do. It's on the website. It's definitely a route that persons take. I haven't heard of anyone from Jamaica taking that route. We are eligible because we are on the eligible H-2B countries list. So as long as we are eligible for an H-2B visa, then you are eligible to have your spouse or your child or children accompany you to the United States. So we have reached the end of our video, and I want to thank you guys so much for tuning in. Thanks to the persons always liking the videos, subscribing, sharing, and leaving your comments. So upon doing your H-2B research, if there is any questions that you may have, you can comment them down below in any of the videos. Also, if there's any topic that you'd want me to touch on, you can always send me a message, or you can comment down below as well. So be sure to remember to like this video, comment down below, subscribe, and share.